Appeals Division 1 is now in session.
Morning. Please be seated. This is the time set for oral argument in SP Syntax versus Federal Insurance. Our cause number 1CA CV140638. Counsels, I'm sure you're aware we have read the briefs. We have conferenced the case. We're well up to speed on the issues, so you can bear that in mind as you begin your presentations. We are being audio taped and videotaped and even shortly to be broadcast on YouTube today, so if you can announce your name and that of the party you represent when you approach the podium, we'd appreciate it. The appellant will have 20 minutes. Each side will have 20 minutes for oral argument. The appellant, you're free to reserve as much of your time as you wish for rebuttal, but you need to watch your own clock. The 20 minutes on the clock includes any time you have left. And with that, we can begin.
Good morning, Your Honors, and may it please the Court. My name is Stephen Sclaver from Sussman Godfrey, and I represent the appellants SP Syntax and SP3 Syntax, otherwise known as Silverpoint. There is one set of rules that applies to all insurance contracts in Arizona that is consistent no matter what type of insurance contract there is: property, fire, home, automobile, or insurance coverage provided to a company that sells televisions. And that rule is that you construe a contract by looking at it from the perspective of an average layman untrained in the area of law or the field of insurance. And the reason for this rule is because individual consumers typically don't have the fortitude or gumption to litigate against an insurance company all the way through judgment and through an appeal. And when looked through that prism and through that canon of construction, if the court puts the two federal policies at issue here side by side, the excess policy and the elite policy, the Side A DIC policy, it becomes clear that the trial court committed reversible error below. The excess policy that federal issued has a specific event exclusion that addresses by name the Syracuse class action. I think that's how you pronounce the class action, Syracuse.
You can just refer to it as class action.
Thank you, Your Honor. The class action is specifically identified in the excess policy. The Side A policy issued by the same company doesn't mention it. They're willing to issue coverage without specifically identifying that as a specific event exclusion. The excess policy has a prior pending date of 2007. The elite policy does not have a 2007 prior pending date. It pushes it back a year to 2006. It is certainly reasonable for a jury to conclude that given those two facts, and when they're given an instruction that the average layman perspective must be considered, that coverage, even for claims related to the class action, certainly would be covered by the Side A policy. And at a minimum, actually, under the Gastar decision that's briefed so heavily, it would be unreasonable to hold otherwise. The main argument that the trial court depended upon in its summary judgment order below, and that federal briefs heavily in its opposition brief, is it's more of a gotcha argument. It's a gotcha that because the insured tendered the claims to both Tower 2 and Tower 1 carriers and got paid from Tower 1 carriers, it is forever barred from seeking coverage from Tower 2. That argument rests on a fundamentally flawed premise, which is that one lawsuit cannot allege different misrepresentations that result in different losses and different damages to different periods. And that's not the law. The procedural vehicle by which you bring a cause of action, whether one consolidated complaint or piecemeal litigation, which is the alternative apparently that federal and the court below is asking for, doesn't dictate whether two claims are related. And in fact, if the court walks through the plain language of the policy itself, it's in the appendix, tab A4, page 170. It's section 7C, the limitation of liability clause. This clause states, all related claims shall be treated as a single claim first made on the date of the earliest of such related claims was first made. It does not say all related claims and unrelated claims shall be treated as a single claim. It's just the related claims are grouped together and severed and shoved back into a prior tower. Under the cases we cite, which includes Home Insurance Company of Illinois versus Spectrum from the Eastern District of New York, a Judge Block case, and W Holding versus AIG, those cases all hold that the fact that multiple claims with different representations are brought in one complaint doesn't mean that all claims are barred from coverage from different tower periods. You can sever the two, because otherwise, and this is in the record below as well as in our brief, it's the report by the expert, Professor Abraham from Virginia Law School, coverage turns on the fortuity of how counsel pleads the underlying facts, as opposed to what the contract says, what the facts actually are. If the facts are, as they are here, in December in 2007, in January in 2008, two insureds, Mr. Lee and Mr. Hodgson, made a private misrepresentation to Silverpoint about a $40 million receivable that was allegedly sitting at an export-import bank in China that they alleged had been vetted by their auditors and that there was no risk to collection. And that misrepresentation, which was made privately after the class period ended in the class action, induced Silverpoint in February of 2008 to make a new set of loans. That's a different set of misrepresentations, a different set of damages to different investors with different objectives. That is not shoved into the Tower 1 period just because the complaint itself included that as part of the claims at issue in the underlying action. And yet, that's exactly what the argument Federal advances here. And there is no case law. They cite no cases.
You seem to have veered very, very far from your opening line about interpreting things according to their plain meaning as the ordinary person would understand them. We started there, and now we're onto fortuities of pleading and it seems like rather Byzantine connections between concepts to get around the fundamental fact that there was a known risk that the parties didn't contract to insure because it would have been cost prohibitive. Can you deal with that basic economic fact?
Well, two things, Your Honor. The first is the reason I tried to diverge into the issue of the procedural mechanism by which a claim is alleged is that's what the trial court relied upon, and that's Federal's primary argument on appeal. We did. Well,
this is summary judgment and de novo review, so.
Yeah. So the risk that was bargained for in the excess policy obviously specifically includes a reference to the class action. And the risk that was bargained for in the Side A policy, it's called elite coverage. It's known as drop-down coverage. Sometimes it's called sleep insurance. It's supposed to provide coverage even when you're sleeping is the concept. There specifically did not bargain for a specific reference to the class action, and the prior impending date was pushed back a year. And the only reasonable inference from those two unassailable, undisputed facts are that coverage would be provided for the class action, even for claims related to the class action, under the Side A policy. Under the excess policy, there is a legal question about whether or not the Helmy causal connection standard applies to the definition of related in this case. That's a separate issue. But as far as kind of the bigger picture of what was bargained for, here you have the general counsel of Syntax who testified at his deposition. He never would have paid the amount of premiums that they paid for the Side A policy if he knew that Federal would not provide coverage, broadly speaking, for any general financial misrepresentations that involved Colin, for example, because Colin was the exclusive supplier of all parts for making of televisions for Syntax Brilliant. That was the whole point of obtaining that type of coverage. And there was a large amount of risk, a large amount of litigation already happening. There was an exclusion in the excess policy that was not included in the excess policy. And the reason in the Side A policy, and the reason for its absence is because coverage should be provided when claims, even if they're related to the class action. There's a stark difference. And in part, that's what and that's independent of the fact that the prior pending date was pushed back a year. That's the analysis that Justice Busbee in the Gastar decision, just in the Texas Court of Appeals, Justice Busbee, clerk for Justice White and Justice Stevens, and wrote a thorough opinion on facts that are really similar here, which is the related claims exclusion in the Side A policy would be useless. It would already exclude all claims that are governed by the prior and pending exclusion if it's construed the way that federal asks. Here, you have a specific date of prior related litigation that trumps the general related claims exclusion provided for earlier in the policy. And given those two conflicting provisions, the specific governs, and you get back to the concept that the argument started with, is you look and construe the contract from the perspective of an average layman untrained in the area of law and insurance. What would someone think if they look at two policies? One has the class action referenced and a 2007 prior pending date, and one doesn't. It's higher up, it's elite coverage, and it pushes back the prior pending date by a year. The reasonable inference, certainly to go to a jury, and we think the only reasonable inference, actually, the only inference allowed as a matter of law, is that coverage should be provided in those two situations. Now, as for the excess policy and the question of whether or not Helmy's causal connection test should apply, the main argument on the motion for judgment of the pleadings below is that Helmy involved an occurrence-based policy, not a claims-made policy. That's true, but that's a distinction without a difference, because in Helmy, the court went on to define what does related mean, and it uses this passage about it's in the eye of the beholder.
Well, that's because the policy in Helmy didn't define related.
That's true. And
where here you do have a definition of related.
But the definition of related here uses the word related.
I know that, but even if you disregard that, it still has other language. It says related claims mean all claims are wrongful acts. I guess I'm reading from all claims are based upon, arising from, in consequence of the same or related facts, circumstances, situation, transaction, or events, or the same or related series. Is that right? Am I reading the right? That's the right definition, right?
Are you reading from the Side A policy?
That's the elite policy.
The elite policy.
Okay. So is there a difference in the? Is there a difference under the? Is there a difference in the?
Well, there's the language in. The language in Helmy.
Let's talk about our policy.
Okay. In
endorsement 25, right? Is that what we're talking about?
That's in the excess policy, not the elite.
We're talking about the excess policy, right?
But related can't mean two different things in these policies if we're taking this plain citizen approach, right?
Well, that's correct. And
so on to Judge Kessler's question, there is a definition, and so do we need to turn to case law?
Well, if the definition of related includes related, you need to.
It isn't limited to related.
Well, endorsement 20. Here's an example.
Endorsement 25 says alleging, arising out of, based upon, attributable in any way, or in any way related, directly and indirectly, in part or in whole, to an interrelated wrongful act, regardless of whether it's the same insured, same or different causes of action, the same or different claimants.
Yeah, correct. The language
and then it refers to interrelated wrongful act as the class action, which is the same as similar or related to.
Okay,
so you have similar or arising out of.
Yeah, so
we will delete the related. I agree with you that you can't define related by saying it's related, but you can say it's related. You can define related saying it's similar to, arising out of, directly or indirectly. That's pretty broad language.
Yeah, and the words arising out of have been construed by Arizona courts to also impute and create a causal connection requirement.
What about similar?
Well, similar is not the reason why the court
doesn't matter. It's a de novo review.
Yeah, that's fine. I do not know of an Arizona appellate case that construed similar to require a causal connection. And so then the issue is, what does similar mean? And here we have different investments, different investment objectives at different times with different misrepresentations and different damages. And you have persuasive authority, even in the financial management advisors case from the Ninth Circuit. That case adopted the logical connection test, not even the more restrictive causal connection test, and held on similar facts. You had investors who both invested in that case in CDO bonds that were advised by the manager, and the court held that's still not logically connected because you have, like I just iterated, different investments, ultimately different objectives, different damages, and different misrepresentations at different times. If under that case it's not logically connected, there is at least a fact question here as to whether or not the class action is similar to the allegations in the Silver Point actions. And they can't even be similar as a matter of law, we argue, because in part the time period is different. The class action ends based on misrepresentations made in SEC filings in November of 2007, and a bulk of the complaint in the Silver Point action involves a private misrepresentation about a receivable that appears nowhere in the public filings in December of 2007, in January 2008, that leads to a new loan in February of 2008.
Let me ask you about that. I was looking at the Danilo, I'm pronouncing his name right?
Danilo.
Danilo. And I'm having a hard time finding where that is, the second loan. I mean, he's directly asked, where's the second loan? And can you show me where I'm looking at page 233. Can you show me where the $20 million revolving loan that you've been discussing is alleged in the complaint? And I can't really find anything about where he says exactly what evidence there is of a $20 million revolving loan that was made based on that representation.
So the complaint specifically references the funding of new money to Syntax Brilliant in February of 2008 to fund professional expenses and obligations. And federal,
the original CFA?
No, that's in October of 2007. That's
I understand that. I'm saying was $20 million was beyond the 20?
Correct. The CFA was about, I think, a $150 million facility, part revolving, part guaranteed.
And so where is that? Where is the new loan revolving? Where is that in the complaint?
Perhaps I can do the following. I can get you that answer during my reply time because it's in there, and it's actually an issue of dispute for the parties because that's one of our arguments is you need to look at the complaint in the light most favorable to Silver Point given the posture. We specifically allege new loans and new losses due to professional fees.
And what's the new misrepresentation? Because I looked at that too and I had a hard time with it because it looked like he was saying that in that same deposition.
The new misrepresentation is about a $40 million
receivable.
The shot receivable. Well, it's a receivable that's paid to an export-import company that's sitting allegedly in China that's being held up for payment to Syntax Brilliant that's been vetted by auditors.
But, I read the deposition on page 237. It says Bird's Nest is the return of $100 million of shot or accounts receivable.
Yeah, the Bird's Nest transaction is a different transaction, a different misrepresentation that we don't allege in the complaint, but it is in the factual record that's developed. Sure. Bird's Nest is a return of inventory.
Right.
The $40 million is a payment for an outstanding receivable. Those are different transactions that Silver Point relied upon. I will get you an answer during reserve time.
Sure.
Good morning, Your Honors. May it please the Court. Michael Nardi, representing Federal Insurance Company, the appellee. Silver Point focused all of its arguments on the related claims issue, and that is the issue on which the trial court based its decision. The trial court properly found, based principally on Silver Point's own words and conduct, that the Silver Point suit and the Sirkidze suit, the class action, were related, making the Silver Point suit a Tower 1 claim and therefore not a Tower 2 claim. But there are at least 4 other reasons to affirm the trial court's decision that do not depend on the related claims provisions and also are based upon Silver Point's own conduct and words. There's the prior notice provision, a separate provision in the policies that independently provides a basis for denying coverage. There's the fact that the underlying settlement in the Silver Point suit is not a loss, as that term is defined in the federal policies. There's the fact that the only theory of relief, the only breach of duty that Silver Point alleged against Federal in the complaint in this suit is that Federal failed to accept the settlement offer within policy limits. There is no duty to defend alleged in this case. That's brought into the case in the reply brief that Silver Point filed in this court. This failure to settle allegation cannot be proven because there is no competent evidence of a settlement demand having been made within the federal policy limits. If a demand was made, it was made and rejected in mediation, making it inadmissible under both California and Arizona law. And the final independent reason why the judgment should be affirmed is that Silver Point cannot and has not even attempted to prove that its Morris agreement meets the requirements of the Morris case, including that the underlying settlement be reasonable in amount. There's been no attempt to establish that, and they can't establish it. They don't have a fact witness. They don't have an expert witness to testify as to the reasonableness of the settlement.
I don't know if the case ever got quite that far, but
well, our case, Your Honor, we did get that far. All the fact witnesses have been disclosed. All the experts have been disclosed. There's no fact or expert witness who can testify about the reasonableness of the settlement. And the settlement,
isn't it a logical precondition to even having a reasonableness hearing that there be coverage?
Well, you have.
I think that's why the case proceeded along the track it did.
Well, you need both coverage and a reasonable amount. And the reasonableness test is determined from the perspective of the insured, what a reasonable insured would pay to settle the underlying case. And the settlement in this case prohibits the insureds from attempting to value the settlement. So there's just no, Silver Point has not even attempted or even responded to our arguments that they can't prove the requirements of Morris and they can't prove a failure to settle. So what they've done is they have shifted the entire theme of their case and trying to allege a breach of the duty to defend. But the federal policies don't have a duty to defend. There are no unpaid defense costs alleged in this case because the Tower 1 insurers paid for the insured's defense. So this whole duty to defend thing is an entirely new invention.
Do you want to touch on the argument about the way Side A is drafted?
Yes. Silver Point says that seems to concede that the National Union primary policy with endorsement 25 is specific enough to exclude claims related to Sir-Kidsey, but the Side A policy does not have this specific Sir-Kidsey or class action endorsement. But the reason for that is not because anybody negotiated to replace the related claims provision with a pending or prior date. The reason was explained by Federal's underwriter in his deposition and in his declaration, is that he felt that the related claims language that was already in place in the Side A policy was sufficiently broad to exclude claims related to Sir-Kidsey. And we deposed SBC's insurance brokers and asked them, did they anticipate or did they consider the language in the Side A policy to be broad enough to include claims related to Sir-Kidsey, even though there's no specific reference to Sir-Kidsey? And both of the brokers, Ms. Franklin and Mr. Caffarelli, testified that the language that was already in place in the Side A policy was broad enough to preclude coverage for claims related to Sir-Kidsey. And Mr. Caffarelli said if you have that language already in the body of the policy, you don't need an endorsement to add it. That would be, he said, belt and suspenders. So the reason there is no separate endorsement is because it was not needed.
It'd be a pretty cheap set of suspenders, though, wouldn't it? I mean, why not?
Because what you do is if you start adding these things, you are undermining the language that you already have. If you have a broad related claims provision, which in our case says it applies to all related claims, and then if you start having to identify specific related claims, you are undermining the breadth of that clause, which is intended to apply to all related claims.
Well,
and it also encourages the insureds to withhold information about claims that may be out there. So
what counsel tells us that on this record, the claims alleged in this second suit aren't necessarily related.
that's what they're telling us.
Action.
But,
And
Your Honor,
because it deals with different representations at different times, and as they say, different damages. How is that not at least a factual question?
well, because that's the argument that's being made. What we have here are two entirely conflicting arguments. Not an argument, not a conflict between Silver Point and Federal, but between what Silver Point said and did before when it was invoking the related claims provisions in order to acquire coverage and benefits under Tower 1. That conflicts with what they're trying to say now in order to disclaim any relationship and recover additional benefits from a second tower of insurance for the same loss, something their own expert, Mr. Abraham, says you cannot do. Let's look at what the Silver Point actually alleged in their complaint, because we've heard about new loans and that sort of thing, and Your Honor is correct to question whether there was any new loans, because there are no new loans alleged anywhere. What they say in starting with paragraph 15 of the Silver Point complaint, it says, by this action, Silver Point seeks to recover damages for the tens of millions of dollars it is owed as a result of the loan made to SBC that would not have been made but for defendant's wrongful course of conduct. Then they go on over the next several pages and talk about this wrongful course of conduct. They have on page 10 a heading, the individual defendant's wrongful course of conduct. They then go on and say there's several categories of representations. There's on page 13, category untrue representations regarding price protection. These are exact same representations that were alleged in the class action. The next category.
Tooling deposits on page 15.
What's that?
Is that what you're going to get to, is the tooling deposits on page 15?
I'm coming to that on page 15. Untrue representations related to the $140 million in assets classified as tooling deposits. Exact same representation that was made in the class action. Next category. Category C on page 17, untrue representations of $100 million in accounts receivable and $60 million in missing inventory. Exact same representations that were made in Sirkidze. This is the shot accounts receivable and the Chinese Olympic Village televisions that were alleged in Sirkidze. Next one, this is where Silver Point focuses its attention. Untrue representations of a supposed $40 million payment held by Chinese Export-Import Company. This is on page 19. Mm-hmm. Counsel says, well, this representation caused Silver Point to make new loans. But that's not what Silver Point alleged. Silver Point says that this representation, in paragraph 70 and also paragraph 8 of their own complaint, they say that representation caused them to refrain from exercising their rights under the credit facility agreement and caused them damages under the credit facility agreement, which is the same agreement they made in the Tower 1 policy period based on representations made in the Tower 1 policy period, which were the same representations that were alleged in the Sirkidze action. The last category of representations that Silver Point alleged, this is on page 20 of its complaint, untrue representations of SBC's financial information made at a February 22, 2008 board meeting. This is where they come closest to the new loan concept, because this is where they bring in the notion of, well, providing funding for ongoing operations. But you have to look at the representations that they say caused them to provide that additional funding. They are the same representations, and I refer you to paragraph 9. It's a little more detailed about this particular representation. Restatements of representations made in the same quarterly reports that are alleged in the class action. They simply said at the board meeting, what we told you before is still true. They repeated the same representations. They were not true for the same reasons. Again, the tooling deposits, the rebates, and so forth. So what happened was Silver Point is lured into a relationship with SBC based upon these representations, the same representations that are alleged in the class action. They'd loan $100 and some million to SBC, and then representations that are the same as or at least similar to are continued to be made by SBC executives to keep that relationship alive, because Silver Point had a choice to make. It could have shut SBC down, but it apparently concluded it was best to mitigate its damages and protect its investment. Excuse me. By, funding ongoing operations to try to keep SBC afloat, and to suggest that that conduct and those representations that caused that conduct are somehow completely unrelated to the initial investment that Silver Point made, and are completely divorced from, have no causal connection to the representations that got Silver Point into the relationship in the first place, is simply just not credible.
So going back, let me make sure I understand
Okay.
your argument. You're going to be working off the definition of related claims in the elite policy,
Yes.
which is at page 5 of the elite policy. Complaint Exhibit 4, PDF 164, right?
Section 7C? Or,
No.
okay, I know where you go.
Page
Section,
5, page 164 of the, actually, our page, it's Exhibit 4, page 5. I was looking at the PDF page.
I'm there.
Okay, so that's what you're working off of, right?
Right, for the Side A policy.
Side A policy.
Right.
Related claims means, I just want to make sure we're on the same page, literally and figuratively.
Yes.
Means all claims for wrongful acts based upon, arising from, or in consequence of the same or related facts, circumstances, situations, transactions, or events, or the same or related series of facts, circumstances, situations, transactions, or events, right? That's what we're working off of.
Yes.
And then your argument is, okay, let's take a look at the complaint. And the complaint, basically, in the paragraphs you've listed, goes over the tooling deposits, the price point, and the three regarding price protection, and
The shot
the
accounts
accounts
receivable.
receivable, and the tooling deposits.
And the Chinese Olympic Village televisions.
Right. And then what you say, your argument is, well, the only other arguments they make are on paragraphs, the titles under E and F, or D and E, rather D and E, I believe, about the account, another, excuse me, untrue representative of supported $40 million payment held by the Export-Import Company, and the financial misrepresentations at the February 2008 board meeting. And then you refer back to paragraph 9, which basically says those misrepresentations were the same thing as the prior misrepresentations.
Yes.
So all they were doing is so your argument is all they were doing is reconfirming the prior alleged misrepresentations.
That's correct.
Okay.
I want to touch on a couple other areas before I finish my time. One is the prior notice provision. There's no doubt that at least some of the events, acts, situations, et cetera, that were alleged in the underlying action, the Silver Point action, were alleged in the class action. And the only ground that Silver Point offers for argument, it offers for saying that the prior notice provision doesn't apply is that they say Federal's Tower 2 Side A policy did not replace XL's Side 1 Tower 1 policy at that place in the coverage tower, and that's simply not true. Well, first of all, the excess policy that Federal issued replaced the Navigator's excess policy from Tower 1. No one denies that. So the prior notice provision obviously applies to the excess policy. The Side A policy replaced at the same place in the coverage tower the coverage that XL previously had provided. XL continued to participate in Tower 2, but it moved its coverage to a higher and new level of coverage at the excess of $20 million attachment point, and Federal took the place of XL at the old $15 million attachment point that XL previously occupied. And the coverage chart that the brokers prepared explains this. The underwriter from Federal's declaration explains that they replaced the XL policy at that point. And I guess the simplest way to look at it is if a claim came in and the loss was between $15 and $20 million. If it was a Tower 1 claim, it's an XL claim. If it's a Tower 2 claim, it's a Federal claim, because Federal took the place of, replaced XL in the coverage tower at that spot. And when Silver Point, or when the Sir action was tendered to Tower 1 and they accepted coverage for it, and the Silver Point action also was tendered to Tower 1 and they accepted coverage for it, they cannot get additional coverage for the same or similar allegations from the second tower of coverage. Next point, this pending or prior date issue. The pending or prior date has nothing to do with the related claims or prior notice provisions. It's not referenced therein. It's referenced in one place in the policy, and that's in a pending or prior litigation exclusion, which no one contends applies here. There's no evidence that anybody negotiated to replace the related claims language with a pending or prior date. There's no evidence that anyone protested Federal's denial of coverage based upon a pending or prior date. In fact, Ms. Franklin, the broker, testified she expected the Federal related claims language to apply to claims related to Sir Because Sir was filed itself after the pending or prior date, she could not have testified that way if she expected the pending or prior date somehow to override or trump the related claims or prior notice provisions. They're separate provisions. They perform, according to Silver Point's own expert, they perform separate functions. We explained in the trial court, and we explained in our chart, which is Exhibit L to our appendix, how the pending or prior date and the related claims provisions work together to place coverage in the appropriate tower. A claim that's related to a claim that was made before the pending or prior date is not covered at all. A claim that is made that's related to a claim between November 30, 2006 and November 30, 2007 is an XL Tower 1 coverage obligation. And a claim that is related to a claim made for the first time in the November 30, 2007 to 2008 policy period is a Federal coverage obligation. And because the Silver Point claim was related to the Sir class action that fell within the XL Tower 1 policy period, that's where the coverage obtains. We're not asking the court to do anything that Silver Point itself didn't do, because Silver Point itself tendered its suit to Tower 1. And Silver Point itself alleges that Tower 1 had contractual and legal obligations with respect to the Silver Point suit. And Silver Point itself acknowledges Tower 1 paid insurance benefits for the Silver Point suit. And what you cannot do is collect for the same loss from two consecutive towers of claims first made coverage. A claim can only be first made once, and that is what they're seeking to do. And you can cite related claims cases, not related claims cases from all over the country. You will not find another case like this one where an insured or its assignee tenders what it calls a single claim, not multiple claims, a single claim, which was a single cause of action and resulted in a single judgment, to one tower of insurance, collects benefits from that tower of insurance, then, after it exhausts that tower, turns around and splits its one claim, splits it into separate pieces, and then tries to collect again from another tower. It doesn't work that way.
Thank you.
Thanks.
Your Honor, to answer the question about where in the complaint and where in the evidence the allegations are made about the $40 million payment issue, There is a allegation in paragraph, and this is in the underlying action, and it's on page 313 of the appendix. Paragraph 103D, sub D, talks about the $40 million receivable at issue. And then paragraph 105, of course, talks about how Silver Point was damaged. And that's also, there are also prior allegations about how this caused Silver Point in paragraph 74 to quote unquote fund operations, professional fees, and other items. That's combined.
But what about paragraph 9? Paragraph 9 of the complaint basically says, by restating and representing the Silver Point that SBC's revenue, this is dealing with the February 22, 2008 meeting. By restating and representing the Silver Point that SBC's revenue, cost of sales, gross margin, operating income in the quarters ending in 2006 and 2007 were truthful and accurate. And these were not true for the same reasons described above regarding the price protection, rebates, tooling deposit, and $40 million was supposedly paid count receivable and $60 million in returns.
I
but
think
those seem to say, I mean, as I read those seem to say all they did at the February 2008 meeting was repeat what they had done in 2007 and 2006 and made real, saying all that's still good.
Well, Your Honor, I think that's an unfair read of the complaint given the procedural posture we're in. We lost on a motion for judgment on the pleadings, a motion for summary judgment, and all inferences have to be drawn in our favor in the light most favorable to us. Sure. There is evidence, it's paragraph 45, for example, in the stipulated statement of facts on summary judgment, page 584
Paragraph 45
of the stipulated statement of facts submitted on summary judgment, and it's page 584 of the complaint, and we quote it in part in our brief, where Mr. Dinello testifies that they provided, I'm quoting, the new advances because the new loans, because they were loans that we thought made sense to provide on their own merit in the 2008 timeframe based on what we knew about the situation with Syntax at that time. And it would be error on appeal, given this posture, to hold as a matter of law that when when Silver Point made this new loan, that it completely put aside and didn't consider the $40 million receivable in its economic analysis.
So let me make sure I understand your argument. Your argument is that if we look at paragraph 45 of the stipulated statement of facts, that will give us, that creates a genuine issue of genuine dispute of material fact dealing with misrepresentations and a new loan. Do I have it right?
That if you're looking at the evidence as opposed to just the allegations in the complaint, correct.
Okay.
I do think under Gastar, judgment should be entered in our favor on that issue with regard to the Side A policy, given the conflicting provisions. But in the alternative, there is a genuine issue of fact about new misrepresentations.
Okay, thank you.
Thank you.
Matter is now under advisement. We will issue a written decision in due course, and we stand adjourned.
Thank you, Your Honors.